Welcome back, everybody, to Use Gentium on the Law Academy. Today, what I'm going to do is speak a little bit about the legal implications associated with the filing of an application on the 5th of March of 2025 by the state of Sudan with relation to the United Arab Emirates. Now, while I'm not going to speak about the conflict in Sudan today in any great detail, the cause and the consequences and all these different kinds of things, because I don't feel like I'm well read enough on that to really do it justice, I will definitely be doing that in the future because the wars and the conflicts and the genocides that take place in Africa are often overlooked, not only in sort of general broader society, but also even within the studies and the academia of international law and international relations. So I will be talking about Sudan extensively over the coming weeks and months. This is just going to be an episode that talks about the filing of the application to the ICJ. So on the 5th of March 2025, Sudan filed an application to the International Court of Justice against the United Arab Emirates, the UAE, with regard to a dispute concerning alleged violations by the UAE of its obligations under the Genocide Convention, under the Convention on the Prevention and Punishment of the Crime of Genocide. This is in relation to the Masilit group in Sudan, and most notably that in West Darfur as well. Now, according to the application, Sudan is concerned in, quote, acts which have been perpetrated by an organisation that goes by the name of the Rapid Support Forces, the RSF, and the militias allied with it, including but not limited to genocide, murder, theft of property, rape, forcible displacement, trespassing, vandalism of public properties, and violations of human rights. And so, according to Sudan, the reason why the United Arab Emirates is associated with this, such acts have been, quote, perpetrated and enabled by the direct support given to the rebel RSF militia and related militia groups by the United Arab Emirates. So essentially, the allegation, if we were to just wrap it up in a nutshell, is that the United Arab Emirates, by giving direct support to the rebel RSF militia and other related militias, they are therefore complicit in genocide, the commission of genocide, under Article 3 of the Convention on the Prevention and Punishment of the Crime of Genocide. Given the fact that by extension the RSF committed genocide in relation to the Masilit group in West Darfur. So this is then therefore an application on account of complicity in the crime of genocide. The foundation of this application looks into both Articles 36.1 of the ICJ statute and specifically Article 9 of the Genocide Convention. We'll get to that in a second. Because in addition to the raising of a dispute and the bringing of the United Arab Emirates to the International Court of Justice, the applicants are also seeking to request a number of provisional measures in accordance with both Article 41 of the ICJ statute as well as Articles 73 to 75 of the Rules of the Court. Now, essentially what Article 41 of the ICJ statute says is, quote, the court shall have the power to indicate, if it considers the circumstances so require, any provisional measures which ought to be taken to preserve the respective rights of either party. Pending the final decision, notice of measures suggested shall forthwith be given to the parties and to the Security Council. So what provisional measures essentially are, in layman's terms, are sort of they're sort of just interim measures that are given that essentially looks to the case, looks to the dispute that is taking place, and says there are concerns that the rights of parties might be violated in the process of this case actually coming to some measurable conclusion. So the court is going to indicate some provisional measures to prevent this from taking place. Now, provisional measures in the case of ongoing hostilities like armed conflicts or human rights violations or allegations of human rights violations or allegations of genocide often involve the parties making sure that they are acting in a way and in accordance with the Genocide Convention, i.e. preventing genocide from taking place. Now, usually, the provisional measures saga, in terms of the controversy with provisional measures, took place quite a lot last year when we looked at the Genocide Convention being brought up in relation to the case of Israel and South Africa. Provisional measures were indicated in that regard, and the standard that was set is, of course, the standard that is often used and has been developed by the court over the years to indicate provisional measures, which is essentially that where there is a dispute that exists, are the rights concerned, or at least are some of the allegations made at the very least plausible to therefore be able to indicate provisional measures. And the ICJ also made it clear in the Myanmar case that provisional measures, the standard for which provisional measures are indicated, are particularly low, and they are even lower when we think about especially the circumstances of erga omnes obligations. The provisional measures that Sudan is requesting are, quote, that the UAE shall, in accordance with its obligations under the Genocide Convention, in relation to the Masalit and the Republic of Sudan, take all measures within its power to prevent the commission of all acts within the scope of Article 2 of this convention. And then it says in particular, and then it lists Article 2 provisions of the Genocide Convention, which of course includes killing members of the group, causing serious bodily and mental harm to members of the group, deliberately inflicting on the group conditions of life calculated to bring about its physical destruction in whole or in part, and imposing measures intended to prevent births within the group. Interestingly, it didn't mention the fifth of these acts, which is of course the transferal of children from one group to another group within the Genocide Convention. The second provisional measure that was requested was that the UAE shall, in relation to members of the Masalit group, ensure that any irregular armed units which may be directed or supported by it, and any organisations and persons which may be subjected to its control, direction, or influence, do not commit any of the acts described in point 1 above, or of conspiracy to commit genocide, of direct and public incitement to commit genocide, and attempts to commit genocide, or of complicity in genocide. Now, because provisional measures are indicated and in accordance with Article 74 of the rules of the court, where it essentially says that a request for the indication of provisional measures has priority over all other cases. Essentially, the idea of provisional measures is to ensure that the rights of parties involved in an ongoing situation are protected in the meantime, in the sort of interim period before a decision on the case actually is delivered, because ICJ cases take years, sometimes even decades. Now, this all sounds very, very interesting, but there is one massive issue with this case. And really, this is why this is going to be a particularly short episode of Jus Gentium, because really, even though this is a step in terms of trying to bring attention to the potential complicity of the United Arab Emirates in the conflict in Sudan and the potential genocide therein, the problem that we really have to think about is the fact that Sudan grounds this complaint because they are bringing this before the ICJ. They ground this complaint in Article 9 of the Genocide Convention. Now, Article 9 of the Genocide Convention says the following. It says, quote, disputes between contracting parties relating to the interpretation, application, or fulfillment of the present convention, including those related to the responsibility of a state for genocide or of any of the other acts enumerated in Article 3. Article 3, for those of you who don't know, concerns the crimes that are part of the Genocide Convention. So things like complicity in genocide, things like incitement to genocide, things like actually committing genocide, that's one as well. Other acts enumerated in Article 3 shall be submitted to the ICJ at the request of any of the parties to the dispute. Essentially, Article 9 of the Genocide Convention suggests that where there may be a dispute, that raises questions as to the Genocide Convention, it is the ICJ, we agree that it is the ICJ that can then bring the dispute, or we can bring, as states, can bring the dispute to the ICJ at the request of any of the parties to a dispute. So essentially this provision gives the ICJ jurisdiction over genocide cases. Now, the problem with this is that the United Arab Emirates has a reservation with respect to Article 9 of this particular convention, which essentially means that the United Arab Emirates does not consent to the International Court of Justice being the venue or being the place where there is jurisdiction to essentially settle the dispute wherever a dispute on genocide may take place. Now, while there are debates about the validity of reservations to the Genocide Convention, see, for example, the 1951 advisory opinion titled Reservations to the Genocide Convention, the court has on multiple occasions accepted the validity of reservations to specifically Article 9. And so the argument that Sudan appears to be looking into, although they don't make this argument very well in their filing of their complaint, is that reservations to Article 9 of the Genocide Convention are invalid because they would any reservation to Article 9 would be incompatible with the object and purpose of the Genocide Convention. Essentially, the advisory opinion from 1951 made it clear that reservations to the Genocide Convention, or certain reservations to the Genocide Convention, will be declared invalid if they are incompatible with the object and purpose of the convention. So, for example, if you want to sign on to the Genocide Convention, but you don't want to accept the definition of genocide in Article 2, well, that would sort of slap in the face of the actual object and purpose of the convention itself, and so reservations of that kind are likely to be invalid, and so therefore you either sign on or you don't, essentially. But the problem with this is that the ICJ has made it clear on numerous cases, in cases like, for example, the Democratic Republic of the Congo versus Rwanda case, two Yugoslavia cases, one regarding the US and the other regarding Spain, and also in that advisory opinion itself in 1951, because they noted that while reservations which contradict the object and purpose of the convention are invalid, they specifically noted that Article 9 does not contradict the object and purpose of the convention, and so it doesn't meet that standard as being invalid. So essentially, Sudan has the uphill battle of trying to argue that Article 9 reservations are invalid, despite the fact that the court, since its inception, has always ruled that and accepted the validity of reservations to Article 9. Which essentially means that there is no legal basis here to claim jurisdiction in this case. That would therefore mean that unless the ICJ does a massive volte-face with regard to Article 9 and then decides that they will instead conclude that Article 9 reservations are invalid, essentially contradicting the last 70 years or so of ICJ jurisprudence, there will be no legal claim, and likely this will get thrown out at the preliminary objections stage. In addition to this, because there is no jurisdiction, it's unlikely that Sudan will get any of the indicated provisional measures that were requested either, because of the basic requirement of prima facie jurisdiction as well. So this is basically a case that will very likely not go anywhere. Now, while some people think that is the case, and of course Sudan will dispute that is the case, and they will try and make the argument that the Article 9 reservations are in fact invalid, it is very unlikely that the court will accept those arguments. But some people have made the point that really the legal merits of this case are not the main issue. The main issue is that this is actually drawing attention to a very serious situation about the ways in which, regardless of whether or not there's jurisdiction, the procedural elements, whether or not there's even standing, the United Arab Emirates has been complicit in acts that may constitute genocide, and therefore, absent any of the jurisdictional issues and the reservations issues, they may be complicit in genocide, even if they cannot sue in the ICJ on that basis. And while that is the case, it just goes to show the difficulty in bringing attention to issues of a political or a geopolitical nature and using the International Court of Justice to do so. And there's probably a much larger and more important conversation, not only about the sort of idea of bringing political or geopolitical questions to the ICJ. That's an important question. But there's also important questions to be said about the validity of, or even the utility of, the Genocide Convention in its entirety. And that's a much broader conversation that I will have, I'm sure, in the future on Ius Gentium and think about this in more detail. But ultimately, that is just going to be something that I talk about in the future. So that's really what we're going to be concluding, and as we've concluded this episode here, like I said, I am going to go into more detail looking at the situation in Sudan, like I said, in more detail once I'm more read up on the issue, talking about the sort of geopolitical implications, the factual circumstances on the ground, the issue of humanitarian crisis, and the role that major players in the region and globally should be playing, essentially, in regards to this crisis. So the African Union, for example, the United States and the Trump administration, all of these different groups as well. That will come in the future, but I just wanted to do a very brief overview of this filing that had been done a couple of days ago, and just basically let everybody know that it's not as exciting as you might think. It's not as groundbreaking as you might think. It's actually going to be something that's very, very likely going to get thrown out, and so the result of that is that there will not be jurisdiction. So I hope everybody's enjoyed it. Like and comment and subscribe as always, and all of these different things. Make sure you share if you want other people to listen to this particular episode, and I'll see everybody for future episodes later on in time.